Hi, this is George Alger with another segment of Our Ventura TV. And today we're going to be speaking about intellectual property. And our guest is Jim McDermott, who is a local attorney here in Ventura. Welcome, Jim.
Thanks for having me.
Jim, what is the firm you're with?
Ferguson, Case, Orr, and Patterson.
Okay, cool. And you mentioned there was like 30 attorneys there?
Correct.
Yeah, it's surprising. I mean, I didn't think it'd be such a large firm in Ventura, so that's cool.
We're fortunate to be growing.
Good. Well, let's just jump right into this topic here. So to start off with the most basic concept, could you define what intellectual property represents?
Well, in the most general level, it's all of the intangibles of a business, for example, that's valuable. So everything that's not real estate or personal property. So it could be a trademark, a patent, a trade secret, copyright. So it's everything that's intangible and that's valuable, and the courts and the government allow you certain rights for being the creator of that work.
Okay. Now I can see how a business would be keenly interested in this, but is there others that would want to have awareness of this as well?
Certainly. I mean, anybody who is an author should be keenly aware of copyright issues. If you're an artist, the same. So I think it applies to anybody who is involved in an intellectual endeavor. Okay.
And then what are some of the, I don't know, basic concerns that one should have once they have awareness about intellectual property as a business owner, an artist, an author, whatever? What are some of the things they should be thinking about?
Well, you don't necessarily just automatically get the rights and have it in the most powerful way just because you're an author, for example. Sometimes you need to take steps to protect it. And it depends on the type of intellectual property, and perhaps we could talk about each type. Depending on the type, you might need to take steps to protect your rights.
Good. Okay, so what are some of the types here?
Well, I think of sort of perhaps in the interest of your audience would be, you would start with trademark. And that is, I think everybody's very familiar with what a trademark is. It's a symbol when you see a product that you say, I know who made that. That's the company, and name the company. Just by seeing the symbol, the color, you know who made it. So it's a store of all the value of goodwill of that company.
And the symbol's a little TM.
Well, I mean by the symbol, it could be anything. It could be the GM, the Apple, it could be yellow.
Logo.
The logo, for example.
Okay.
Or the name. That's a trademark. It's a mark designating the source of that good.
Okay.
So you don't have to do any research to figure out who made this. You know when you see that yellow color, it's a caterpillar something or other, for example.
Okay.
You see the Apple logo, you know who made that. And all of your feelings about that company, hopefully positive, are sort of stored in that mark. So trademark is a key one. Trade secret is another key type of intellectual property, and that's most generally any information you have that's valuable because somebody else doesn't have it. So classic example is a recipe. If you came up with a special recipe for Coca-Cola or cookies or something like that, or for some manufacturing process, that's yours. So long as you keep it a secret.
And then when it's not a secret, it is no longer intellectual property?
Well, that's it's no longer your exclusive intellectual property. And that's a key distinction between trade secrets and, for example, trademarks, and we'll talk about patents, is trade secrets only valuable to you. You could only protect it so long as you take the efforts to keep it secret. So you want to make sure that when you have employees exposed to it, that they too agree to keep it secret. So that's a unique aspect of trade secrets.
Okay.
There's no sort of registration of trade secrets. You just have to take diligent efforts to keep it that way.
Okay.
But it's, you know, it could be of tremendous value.
So patents fit into this as well?
Patent is anything that's sort of a new and useful item of, you know, machine, in some aspects could be a process. So if you come up with that new machine and you apply for a patent and you're granted a patent, That's the right to exclude all others from making that. So that's a very clear line, and it's a significant distinction between a patent and, for example, a trade secret. A patent, you put it out there in the world. You tell the the patent office exactly what you're going to do, how you do it, and they make the decision whether it's patentable. But once they do, you have that very powerful right to exclude others.
Okay.
And then we have copyright is another type of intellectual property, and that's any sort of creative expression that you have. You write down a poem, draw a picture, that's yours.
Now, do I understand this correctly, that when you do write something down, whether it's a poem or an article or a book or whatever, that you don't need to formally register it with an authority that it is copyright, it's implied copyright or something like that?
No, that's a great observation, and that's a key misconception I come across frequently, that people think you have to, and you used to have to register your copyright, but copyrights rights come into place when you simply write something down or affix it to a tangible medium is the legal term. So you have those rights right away. Same with the trademark. When you put a brand on something and you sell it, you don't need the government approval to do that. You don't have any, you get rights by using it. There are key advantages, of course, to registration, both to trademark and copyright, but they're not necessary, where they are necessary for a patent.
Okay. All right, so do we cover all the different types of intellectual property?
Primarily, there are other, this is a creature of statute, so new ones come along. You could have a plant variety protection. You could have a boat hull registration protection. Rights of publicity. So there's basically anything you could really conceive of, there might be an area of law that protects it. So there are others, but the primary that would be of interest to most would be trademark, copyright, patents, and trade secrets.
Okay. Now, what in your experience are some of the main mistakes that people might make around their own intellectual property?
Well, I think one of the key mistakes is if they have something of value that they don't take any effort to protect it in the case of trade secrets. That they sort of assume if they're not a software company or a tech company that they don't have any intellectual property that's valuable. So they might have a really unique recipe, process, or list that's very valuable to them that they take for granted and don't take any real efforts to protect it. And when perhaps employees leave and take that with them, then they start seeing all the value in it, but it's many times too late. So just not taking proactive steps to protect their property is probably the foremost problem I see.
Okay, could you give an example of a common step that a person might take to protect some type of intellectual property?
Well, it depends on the type, but for example, a trade secret, that's more involved, that you really, it's critical to have processes in place where you have employees sign agreements saying they agree to take things, maintain the secrecy, that when you give things to vendors, you might have agreements with them. So trade secret's a little more intense. Another common one I see is with websites, that businesses have third party make their websites, and they don't have any agreement. And then when things go south, the person has a control over the website, and they say, hey, I made this, and you have a tangle over that. Very simple on the front end to deal with that, with a work for hire agreement, saying you're doing this for me, but it's my product. That's a very common one I see too.
Yes, okay. So in terms of let's say an artist, all right, so what should an artist think about in regards to intellectual property? Well,
an artist should be, copyright would be the first consideration, anything they do. And if they have something that they think is of key value, they should register it. There's real advantages to registration. One, just other parties might be less likely to try to take it because they see that it's registered. You have the right to get certain statutory automatic damages by having it registered. That could be a valuable deterrent. And attorney's fees, which can be significant in that type of litigation. So there are real advantages to registration. It's a very simple process.
Okay, and also so that I'm fully in sync with you, in terms of someone, quote, taking it, what does that mean? I mean, is it copying a visual form or copying a written form? What are we actually referring to here?
Well, that's a very complicated, in some cases can be very complicated, but most simply in a book it would just be copying. Okay. When you talk about visual arts, it could get more, if you're not just taking a picture off the web and copying it, but you're kind of modifying a little bit, that's where you get into sort of the interesting area of, did you transform that work? So that's frequently an area of, a lot of debate, of course.
So the transforming it is kind of an important term here?
Well, it can be. I mean, and the other aspect is if you're taking it and making a parody of it. A classic example is there was a case of the Barbie dolls, that somebody took Barbie dolls and he made, little violent scenes, mock-up violent scenes with the Barbie dolls, and made a sort of a mockery of that concept, and it was deemed to be fair use. So you still have your First Amendment rights. I mean, realize that's really the conflict here, is you have First Amendment rights, and the courts are very sensitive to that, of course. So that's a balance that always exists. Okay,
but in terms of transforming, is there some general notion then that if you're inspired by visual art or some music or something that you hear, you can sort of create around the corners of it?
Yes, you can. I mean, the whole concept behind intellectual property is that we want to further the arts, further industry. This is to motivate people. The government's giving you a grant, in some cases an exclusive grant, to go do something, and the thought is you motivate people by allowing them to profit from it. But if you're protecting it so broadly that you're cutting out other people and endeavors that would naturally come about, then you're not really furthering that goal. So you do want there to be development. You want to have people able to transform the arts, for example.
Okay. Now, I've heard various stories of copyright problems over the years, and some of it are because the person didn't protect themselves. Others are because the person just got wrapped up in various legal proceedings. In your experience, is the legal protection, the system that's set up, is it actually fair and workable?
What's the other alternative?
I don't know.
There is
I guess is there room for improvement?
I think there's always room for improvement. I think there's particularly in relation to copyrights. I think a lot of artists might chafe against the existing system and think, you're giving too much to the authors and perhaps the industry.
Oh, okay.
So, I mean, you have the exclusive right to that work for the life of the author plus 70 years, and sometimes for work for hire for much more than that. So it's a pretty serious grant. But at the same time, people put a lot of effort in developing things, and they should have the right to protect that. So it's not a perfect system, but I think without a doubt it's the best that exists.
Okay.
So I would be very wary of tinkering with it very much.
Okay. Then we're just about out of time here, but you mentioned the cost. So can we just speak broadly about the cost of intellectual property protection?
Yes. I mean, we were just talking about litigation, and that's a whole nother world where and we don't do patent litigation, but that could be several $1 million with ease. So patent litigation is sort of specialized, and it's extraordinarily expensive. But just for the person coming in and wanting to protect something, the filing fees, just the filing fees for a trademark, are roughly $500. The filing fees for a patent could be anywhere from $8,000 to $20,000. Copyright is very modest. But the filing fees are a small part of it. A lot of the cost, if the person doesn't do it themselves, would be in the attorney's fees. And that really just depends on what type of issue they have. The more complicated, obviously, the more expensive.
Okay. So Jim, there's a lot I can see we could discuss in this particular area and probably never even fully explore all the opportunities to talk about. But we are out of time, but I'd like to offer an opportunity for viewers to find out more if they're so inclined. What would be a website, for instance, they could get touch bases with you on?
Sure. Our firm website is fcoplaw.com.
Okay, and that's right here in Ventura.
Yes, it is.
Okay. Well, Jim, thank you very, very much for stopping by.
Thank you. Enjoyed it very much.
Great. Well, this is George Alger signing off for this edition of Our Ventura TV. Until we see you again.